This is Barry Zalma speaking for Claim School Incorporated's blog and newsletter, Zalma's Insurance Fraud Letter for January 2, 2025. This volume 29, issue number 1, wishes everyone a happy new year. Zalma's Insurance Fraud Letter, ZIFL, starts its 29th year of publication, dedicated to those involved in reducing the effect of insurance fraud. ZIFL is published 24 times a year by Claim School and is written by me. It is provided free to anyone who visits the site in the newsletter and in the blog that allows you to subscribe to Zalma's Insurance Fraud Letter. This issue contains some of the following articles about insurance fraud. First, the COVID delay of trial was appropriate, and there was no right to trial if the defendant waived the right to a speedy trial. On February 12, 2020, the state charged Franklin Lee Boger with one count of level 2 felony arson, resulting in serious bodily injury, 4 counts of level 4 felony arson, 1 count of level 6 felony arson, and 1 count of level 5 felony insurance fraud. Boger's trial was set for a certain date, continued with the agreement of Boger several times without his agreement several times. He appealed in a case called Franklin Lee Boger versus State of Indiana, where the Court of Appeals of Indiana on December 5, 2024, refused his request for dismissal of the charges because of the delays. You can read the full article and all 25 pages of this issue of ZIFL at the link provided in the blog. Next is an article about a doctor convicted of health care fraud and tax fraud in a case entitled United States of America versus William Weiner, decided by the United States District Court for the Southern District of New York on December 18, 2024, where defendant Weiner pled guilty to conspiracy to commit health care fraud and tax fraud. On September 19, 2024, the United States District Court sentenced Weiner to time served and 2 years supervised release, but deferred its determination as to restitution. The government now sought an order directing Weiner to make restitution to one Farmers Insurance Exchange in the amount of $334,612.22 and to the Internal Revenue Service in the amount of $76,127. You can read the full article and all 25 pages of ZIFL at the link provided in the blog. Then there's more McClenny, Mosley and Associates issues, this being ZIFL's 40th installment of the saga of McClenny, Mosley and Associates and its problems with the federal courts in the state of Louisiana, and what appears to be an effort to profit from what some magistrate and district judges consider criminal attempts to profit from insurance claims relating to hurricane damage to the public of the state of Louisiana. You could read the full article at the link provided in the book. Next is an article about an ex-police officer who was found guilty of fraud and many other crimes, and his convictions for multiple crimes and insurance fraud were affirmed by the Court of Appeals of Ohio in a case called State of Ohio versus Von Harris, decided December 12, 2024, where he claimed multiple errors at trial, all of which were affirmed by the Court of Appeals. You can read the full article and all 25 pages of ZIFL at the link provided in the blog. Next is an article about attempts to compel ethical behavior while attempts to defeat fraud. Some states have attempted to compel insurers to act ethically and in good faith because of a perception that insurers were deceiving those insured. For example, the California Insurance Code contains a Fair Claims Practices statute that sets out multiple acts that the legislature considers unethical and an unfair claims practice. You can read the full article about the attempt to make insurance people act ethically at the link provided in the blog. Then there's the article on health insurance fraud convictions, starting with the fact that a Southern California-based clinic, laboratory, and the owners of the clinics and laboratories agreed to pay $10 million for false claims arising from kickbacks and self-referrals. Mohammed Irezeki, Sheila Boucheri, Southern California Medical Center, and R&B Medical Group, doing business as Universal Diagnostic Laboratories, agreed to pay $10 million to resolve allegations that they submitted false claims to Medicare and California's Medicaid program known as Medi-Cal, arising from allegations of paying kickbacks and making self-referrals. The defendants, all based in California. Rasheki is the founder and chief medical officer of SCMC and the co-owner of UDL. Boucheri is the chief executive officer of SCMC and the co-owner and chief executive officer of UDL. SCMC is a federally qualified health center that operates 6 clinics in Southern California. UDL is a reference and esoteric laboratory in Southern California. You can read the full article and reports of dozens of additional convictions and promises to pay the government money, and all 25 pages of ZIFL at the link provided in the blog. Next, there's an article about convictions of other than health insurance fraud, starting with an Iowa contractor who agreed to a consent order over unlicensed public adjusting. Central Iowa Gutter and Donald Smart agreed to make changes to stop holding themselves out as public adjusters or providing any public adjuster services on their websites, social media pages, and advertisements in exchange for avoiding jail. You can read the full article on all 25 pages of ZIFL at the link provided in the blog. Next is an article called The Start of the Tort of Bad Faith, with a reference to the decision in Kritz versus Farmers Insurance Group, a decision of the California Court of Appeal on November 18, 1964, where plaintiff Betty Kritz, a passenger in an automobile driven by her husband, were involved in a collision with an automobile driven by David Arnold. Arnold lost control of his vehicle while trying to negotiate a curve. His automobile crossed over to the opposite side of the road and crashed head-on into the Kritz car. Mrs. Kritz received numerous injuries, including the loss of sight in one eye and fractures of the neck and jaw. Arnold had liability insurance issued by defendant Farmers Group with a coverage limit of $10,000 for injury to one person. It was clearly not enough to compensate for Ms. Kritz's injuries, and yet they refused to settle for even the full policy limits. You can read the full article in all 25 pages of ZIFL at the link provided. Thank you for your attention.